In this module, we will cover the European Court of Human Rights, also known as the ECTHR. To do so, we will first need to introduce the European Convention on Human Rights, formerly the Convention for the Protection of Human Rights and Fundamental Freedoms, which will be detailed in the next module. The European Convention is an international treaty to protect human rights and fundamental freedoms in Europe, including parliamentary democracy and the rule of law, and to ensure that the atrocities and cruelties committed during the Second World War would never be repeated. The Convention was drafted in 1950 in the aftermath of the war by the then newly formed Council of Europe, including the United Kingdom. All Council of European member states are party to the Convention, and new members are expected to ratify the Convention at the earliest opportunity. Incidentally, the Council of Europe should not be confused with the Council of European Union or the European Council. The European Union is not a party to the Convention and has no role in the administration of the European Court of Human Rights. The Convention established the European Court of Human Rights, or the European Court. This is a permanent court with its own official languages, English and French, its own judges and its own rules of procedure. It was established to give authoritative verdicts on the European Convention. Any person who feels his or her rights have been violated under the Convention by a state party can take a case to the court, which hears complaints that a contracting state has violated the human rights enshrined in the Convention and its protocols. Judgments finding violations are not binding on national courts. However, they are binding on the governments concerned, which are obligated to execute them. Nevertheless, the European Court does not prescribe the remedy beyond damages to be paid as just satisfaction to the applicant. Nor does the European Court decide how it should be implemented. The necessary steps must be taken by the national authority to remedy the circumstances that led to the European Court's judgment. Each signatory state appoints a single judge to the court, but the judges are not the representatives of their state. They, instead, sit in an individual capacity,